omitted to mention a Group 6 matter ready for hearing, my lord. Affidavits have been completed, my lord. I've already given notice to other side, my lord. It's a for year of 2020, my lord, of Bose Institute, where, my lord, a service dispute, wherein, my lord, pursuant to direction of of Ministry of Department of Science and Technology, the promotion of the technical officer has been downgraded, my lord, which is beyond the scope, my lord. Although affidavits are completed, short point, my lord, if my lord kindly takes it up, my lord.
Yes.
Almost on the same matter, my lord.
Group 6 matters.
Yes, because our matter is something different. Our matter is after the retirement, long back, 90s, 80s, half of the pensioner already retired. Therefore, there was a circular by the Ministry of A. That is inconsistent violation of the consistent precedents of the Supreme Court, that after the retirement, the guidelines also given, no deduction can be made. And even recently, Bench of Justice Coke, they set aside the judgment of the Calcutta High Court in this transport terms of adjournment. It is a settled law. So our matter has the hard. Merit is different. His matter is that they are in the employment, but our matter is we are not in the employment. We are retired long back. So this should be, my lord, segregated, and hardly 5 minutes it will take.
Now, who is for the state?
State, my lord, this is Group 6 matter, my lord. This is Union of both institutes.
Who is appearing? Do you know?
In fact, I am appearing because it has been tagged. Unnecessary. It has been tagged. So we don't. It's different. Our matter is that whether after the.
Okay.
My
May I have your lordship leave to
Yes, Mr. Mondo.
item number.
So therefore, these should be, my lord, segregated. Because otherwise, because at least one hearing took place earlier.
No, let it be listed first.
Yes, my lord.
I will pass them.
My lord.
Okay, they will be listed first.
My lord.
I will take up the record and hear the matter. Okay.
Yes. But it will take hardly 5 minutes, my lord.
Okay, very well.
Alright, item number 150 and 51. It's a part heard matter.
Which matter?
In your my lordship's list. Item
Yes,
number
I
1.
understand. So,
This is, my lord, that
Singh
matter
is
which was
there.
not heard on the last day. This is a case of amputation, my lord. Mr. Singh is the other side. It is ready for hearing. My lord has heard it at length.
You have initiated the matter.
Yes. Yes. It
You
is.
got the claimant.
Yes. 150, 151. Mr. Shashwata Bhattacharya was appearing.
I understand.
Yes, he was arguing the matter. If my lord kindly gives one date, any date your lordship pleases, I'll inform Mr. Singh and Mr. Shashwata Bhattacharya will be there to argue the matter. Any date your lordship so pleases. If it is possible.
Next week?
Next week, any date, my lord, any date.
Tuesday. Next week at 2 p.m. Tuesday, 2 p.m.
Next Tuesday, 2 p.m.
Next
Grateful,
Tuesday,
my lord.
Item number?
150 and 51. Only
one
one
matter
part
is-
had matter.
Only one part had matter.
Grateful, my lord.
Yes. Please take the microphone.
May permitted to one matter, Group 8 matter.
Yes.
This matter was heard on 2nd May 2024. After hearing all parties, there is raised opposition and reply, and matter considering the gravity of the matter has been fixed on 11th June. But due to change of determination, I have annexed the order sheet of my Lord Justice Bivas Pattonayak, as his lordship
So,
then was.
is it a parted matter?
No, Pathan. His lordship, considering the gravity of the matter has been fixed on 11th. I have annexed the order sheet, my lord. 11th June has been fixed.
11th June means today.
Today. So I matter is not in the list, so I am mentioning.
You must have mentioned on the 10th. That is yesterday. You are appearing on behalf of the petitioner. Petitioner. Who is for the state?
Which that is their name.
Tanmoy Chakraborty and Debraj Saha.
In their presence, that order was passed. On
For the private respondent, Devabrata Sahara.
in all
Bengal
presence of
Bhattacharya.
all parties, the order was passed. And considering the gravity of the matter, there is some suppression of the facts of the Honorable High Court's order, for which the dealership is enjoying since 2007 till today, suppression of the fact. So considering the gravity of the matter has been fixed, giving the particular date, 11th June.
এখন করতে হবে অন মেনশনিং করা আচ্ছা অর্ডার ফাইল নেই ঠিক আছে আজকে স্টে দেবেন কি করে কাল থেকে let it be listed tomorrow. Okay.
Tomorrow I have some difficulty. Some matter is before the
So day after tomorrow.
day after tomorrow. Yes.
Okay, day after tomorrow. List it on day after tomorrow.
My lord, may I,
Of that.
my lord, may I be allowed to mention one Group 6 hearing matter upon notice, my lord?
So she may be permitted to mention 2 Group 6
Great.
hearing matters for inclusion in the list.
Okay.
Grateful, Lordship.
Call the list.
But I appear for the petitioner in this matter. But there is a matter which was heard and an interim order was passed on 5th of December. It was extended from time to time and it was lastly extended on 19th of April 2024. If your Lordship kindly sees the order of 19th April 2024, your Lordship will find that it was extended from time to time and the state is yet to file their opposition in this matter. So, I was paying before your Lordship for extension of the interim order which is to expire.
Mr. Rudrajit Sarkar and Devanshu Dinda, they are appearing on behalf of the state.
Yes. Now, we have already given a notice saying that this matter is to come up before your Lordships today, for extension of interim order.
Please take down. Mr. Probal Mukherjee, senior advocate, appearing on behalf of the petitioner, submits that the state authority respondent was directed to file affidavit in opposition, but they are yet to file the same. However, the interim order passed by this court on the earlier occasion, which was extended time to time, is expiring soon. So he prayed for necessary order for extension of interim order. Full stop. Next paragraph. It appears that the interim order passed by this court was lastly extended on 19/4/2024. It further appears that the state has not filed affidavit in opposition in spite of direction of this court. Considering the situation, I think it necessary to pass an appropriate order. Accordingly,
তুমি আছো? বলো।
are you appearing in this matter? What is your submission regarding affidavit of opposition?
That has to come from the department who have sent it. Please see 2 weeks time to file the same. In the meantime, kindly
No.
I got my submission, but
In the March
I
of
don't want to say-
March 2024, you are directed to file the affidavit in opposition within 2 weeks. Now we have already passed 3 months, 4 months like that.
And in the meantime, there's another complaint against them. In the website, they are showing that the factory's license is cancelled. Although there is an interim order passed by this honorable court. They have to correct the, my lord, the website information.
Then I will deal with it, but I cannot take instructions on behalf of an oral submission. Lordship, kindly appreciate.
No, it is on my,
I
no, I have,
understand.
I have
So
got a copy of
What
my lord, the
prevented you to
website.
file the written affidavit in opposition?
Last of the Lordship, give me a fortnight, I will file.
Always 2 weeks, but 2 months plus. You have to take some initiative so that the order of this court can be maintained. You are the officer of the court. You understand the situation here.
The preemptive chance, I will file.
So it would be better to give you a 3 weeks time. You have to, okay.
এইটা রেখে দাও ওই ক্লায়েন্টকে
Sir,
দেখিয়ে
কি
দিও
বললাম?
অ্যাপ্লিকেশন কর
আচ্ছা, আমার কোন
হ্যাঁ ঠিক আছে আরে
ডিপার্টমেন্টের ব্যাপার
ইনফ্যাক্ট আমার
Considering the
কনসেপ্টের একটা অপশন আছে বাট দেখা যাক চলো
after period. Hence it is ordered that the interim order passed by this court on the earlier occasion is further extended for a period of 6 weeks from the date or until further order whichever is earlier. Full stop. The
তুমি পারবে আচ্ছা আমি বলে দিই
state is directed to file affidavit in opposition within 3 weeks peremptorily. Let the matter appear in the list in the 4th week of July 2024.
But the interim order, my lord, for 6 weeks,
6
may it be
weeks.
for, my lord, 8 weeks, my lord, because Lord, your lordship has seen, my lord, from time to time it was extended. But I do not know whether the
Expiring
state will be able to
1,
file.
2, 3, 4, 5, 6. Okay. 8 weeks.
Grateful, my lord.
Under the heading hearing.
I am for the petitioner in this matter.
My lord, I appear for the respondent number 1 and to the port trust, my lord. My lord, we have been recently briefed in this matter. I am seeking two. Respondent number 1 and 2. State port. Port trust.
Port trust.
This is
not the
not
port-
the
port
related to the port trust.
Okay.
Whole matter বলছি।
My lord, I beg to appear on behalf of the state here.
This is subdivisional controller, block development officer at the
Yes.
respondent authority. This is not a matter of port trust or otherwise. So what is the issue here?
My lord, the things for a moment, I'm just drawing a lordship's attention. The petitioner was the MR dealership for distribution of the MR codes in 2006. In 2007, the dealer was ill. He was not able to continue the service. So there all the ration cards tracked with the other ration holders. Thereafter, my client, after resuming the feed, made the application for renewal of the license. No, that was not considered. I come before this honorable court. Lordship, kindly see the order passed by Justice Bakchi, annexure page 45.
Page 45.
Yes, annexure P 9. Oh, sorry, page. Justice Joy Mandar.
WPA 4346.
No, this is not that. Page 28. Passed by Justice Jamal Bakshi. This has been made, my lord. During the pending of the read application, a notification has been issued for inviting fresh applications. This is page 20.
What page are you referring?
Page 28.
28.
Yes.
Okay. Eligible.
This order has been passed by Justice Bakshi. My lord, during pending of the application, the authority, my lord, issued a fresh notification for fresh inviting applications in the said area of Indopur Moja. When that has been notification has been made, the honorable judge passed an order. When the application invited, you made the application before the concerned authority, that will be considered.
Very well.
That much. My client made the application. Thereafter, my lord, all the process has been completed. I have been succeeded, but the license was not issued. I come before the Honorable High Court again for disposal of the or to give the license. I made the deed. That has been made, page 45. No reason order has been passed. That's why I come before this court.
Vacancy was cancelled.
Yes, madam.
Vacancy was cancelled. It was the submission of the state.
Submission state. On that basis, the final order has been passed. Justice Abhijit Gangopadhyay, whatever may be. When the cancel has been cancelled, that order that has been finally disposed of on page 49. This matter has been finally disposed of.
Page
49. This order has been passed by Abhijit Gangopadhyay. Matter was dismissed since the cancel on the basis of the enforcement of 2013 Act. Against that, got
Yes.
lordships. Against that, I prefer the appeal before the division bench. Okay, division bench. The division bench holds. Next page 51. Division bench held. Page 51. Lord, I am drawing lordship's attention paragraph 2, 3, and 4 of the order. Got to lordships. Paragraph 2, 3, and 4. Admittedly, my lord, during pending of the proceeding, fresh advertisement made. I could not make the application during the pending of the proceedings. That has been held in the observation, and then liberty is given to file the application. I made the application along with the following letter, the next page. Along with the following letter and the application, all the things has been received by the concerned respondent authorities. All the documents. In terms of the division bench observation, I made the application. Now the subject matter is kindly appreciate Annexure P14. They have said that since my client did not make the application within the time as mentioned in advertisement, this has been communication only that. I am this such way, this is the wrong interpretation of the order of the division bench. So my respectful submission, let the reconsider the matter. The last paragraph, Your Lordship, it is mentioned here that such and such.
Read out the paragraph 4.
Yes,
Paragraph 4 of the
I'm just,
division bench.
yes. This is, my lord, the paragraph for intention is that. Before that, paragraph 2 for a moment. Paragraph 2, I'm just drawing Lordship's attention 2, 3, and 4.
Yes.
2, Your Lordship, kindly the applicant submits that 9 September, Your Lordship, government has invited the application such and such date. The petitioner may be allowed to apply in respect of such vacancy. Next paragraph 3. The learned counsel for the applicant has submitted that in view of the pending of this appeal, an application was filed. That was issued in the time of the not issued the single bench. My contention is it is an admitted position. My client did not file the appeal within the time. This is admitted position that has been observed by the division bench. And the admitted position. And that's why the paragraph 4, if the application is made subsequently, that should be considered. On that basis, my client made the application. I cannot be on the records. If the vacancy still exists, vacancy has not been filled up as yet. The intention of the order of the division bench, it is admitted position, my client could not make the application.
So the notification was issued on 9th of August 2023.
During pending of the proceeding, all the things. During pending of the division bench.
And what is your submission now? The proceeding, the proceeding was exhausted or not?
Not exhausted. If it is exhausted, then I have nothing to say. Vacancy still in force. If I am not in fill up. And immediately my client made the application along with the foreign letter granting advocate, and that has been received by the concerned respondent. In spite of that, they have stated with the wrong interpretation that the application has not been met within time. It is admitted, that is a record. My client could not. So my respectful submission to this man, let the matter be reconsidered or in appraise. It is not that my case has been rejected or my case has been, my lord, permitted, has nothing. Only things, observation, application has not been made.
So now what you want?
Let my application be reconsidered in appraise. Since the vacancy existing, vacancy has not been filled up. The entire exercise by the division bench option has been made, my lord. Observation is itself. If the vacancies exist,
if the petitioner is eligible to apply, this is the term
that is
mentioned by the division bench.
That is my principal submission. If it is so, what my status? It is admitted position. I kindly appreciate. Admitted position, the division bench held. I could not make the application.
Then you file a rejoinder before the division bench. Then you file a rejoinder before the division bench.
No, division bench already.
Your limitation was not condoned by the division bench.
Things for women versus.
Admittedly, you know that the notification was issued on 9th.
That is the record.
That is on record.
That is the record.
You know that.
No.
But you have not prayed for any condonation of such period.
No, my lord.
Before the division bench.
My respectful submission to that. What
division bench just termed it if the petitioner is eligible to file an application.
Yes. My lord, what happens, my lord?
The term, the period has already elapsed.
Only the eligibility gone. My lord, otherwise my client is entitled. Only the things for period of limitation. Limitation, it is admitted position. I could not make the application since the matter is pending before the High Court. That is admitted in the division bench. That is admitted. Thereafter,
file a rejoinder before the division bench.
That the matter is already disposed of. Appeal court has been disposed of. In terms of the appeal courts, I made the application. I made the application before the concerned authority. Admittedly, I could not make the application in terms of the notification. Otherwise, I am
I
qualified.
understand the issue. I understand the issue.
I otherwise qualified. I am entitled. I have the go down and other things I am, and all the things are entitled.
That is the matter of issue of the inquiry or anything. That is the other-
Technicalities
that
that
is-
comes
the-
later
the
part.
agreement, sir.
Later
That- the agreement, sir. That was in earlier occasion. All the query has been done. All the process was completed. I was qualified just before issuing the license. My lord, the notification has been stopped by virtue of the amendment in force of the 2013. This is the case. What I'm telling, my lord, my respectful submission only relating to the lack of the limitation, which has been division bench already admitted the question, and thereafter the purpose.
Division bench admitted the position but did not condone the delay.
I do appreciate. I
This
do
is the
appreciate.
term.
I do
We
appreciate.
all bound by the order of the division bench
No, if it is
that
so-
if the petitioner is eligible to apply.
No,
What's
what
the term?
no, that is term. But why, if it is so, my client could not make the my lord, only things.
I
I
cannot
just only
interpret now the order of division bench,
my lord, my lord,
sitting in a single bench.
my lord,
You understand the situation?
my lord, silence. My lord, anything. May I be succeeded or may not succeed. One of these. My lord, the admitted position, the division bench in confined that the petitioner could not make the application.
Yes, yes.
Then what purpose of passing if the application is made before if it is the petitioner entitled, what purpose? Not required at first. What purpose? This is admitted position. I could understand the division bench did not consider touching the question.
Okay, read out the paragraph 5.
Yes, ma'am. Yes, ma'am. We make it clear that we have not gone into the eligibility of the petitioner. Eligibility
The petitioner to apply in terms of the notification dated 9th August 2023. That has not been touched by the division bench.
I do appreciate. Eligibility, so far my little knowledge, eligibility is otherwise. Suppose a person make the application, he has no other eligibility apart from the limitation point. Not only the limitation point, other points is there. If his eligibility, he has the other eligibility. If he is not, I could understand only the point. The point, only limitation point has been dealt with by the division bench, though it is not the clearly, but it is indication or intention of the order. Eligibility means not only the limitation point. Eligibility means other criteria also. He
Yes,
has the
it
other
includes also the point of the file date of
include the
filing,
points.
everything.
My lord, the only my responsible submission include the point. I do appreciate, my lord, including the point. So far, the point of limitation or could not making the application within time in terms of
What purpose would be served by passing an order to reconsider your matter? What purpose would be served?
purpose,
They
my lord.
also bind by the order of the division bench.
My lord, my responsible submission, two things. My lord, the post still
I
exists.
cannot now condone the delay, you can understand. I now, being a single judge, I cannot condone the delay, you can understand.
I'm
If
not.
you want to proceed with this matter, I can proceed by
I'm not.
taking affidavits or
I'm-
otherwise.
I am not such making submission or prayer before court. My submission only to that respect is interpretation only. So far the point of limitation making the application, saving other eligibility criteria. The person not only the point of limitation, person eligibility means he has the other criteria also.
Who is appearing for the state? You are appearing for
These
the
other
state?
also
What is
criteria.
the status of this procedure?
No, the procedure, Millet, kindly for a moment, Millet, hear me, the entire procedure. Millet, Lordship,
Concluded the entire procedure?
kindly do not go by the procedure. Today, Lordship is sitting on the 226 jurisdictions. Now, there is a order passed by the division bench. The petitioner is bound by that order. Which is fallen from your Lordship, Millet.
I understand every situation. I understand the all submission. I just want to know what is the stage of the procedure.
Millet, Lordship, kindly take travel to see page 48. Let me, Millet. Page 48. This is the
48.
40. Have your lordship got it, Miller?
Yes, this is a notification.
Yes. This is the notification. Notification speaks that the in view of the implementation of the National Food Security Act 2013 in the state, the governor is pleased to cancel with the immediate effect of the FPS vacancies notified by number such and such, such and such, such and such, such and such, such and such. No further action will be taken in connection with the application received against such vacancies. So thereby
That was cancelled.
that
That was
is
cancelled.
absolutely cancelled.
Entire procedure has been
Entire process
exhausted.
has been cancelled. Now the new act is came into the force. When the new act came into the force, the procedure is that the vacancy has to be declared. Right? Once the vacancy is being declared, the person concerned has to make an application to the Miller website on the online. There is no offline system is there. After the Miller, the same is being done. Generally, Miller, the technical criteria would be looked into. Thereafter, the minute inquiry would be held. If Miller, the petitioner is passed, the Miller, the first hurdle of the Miller technicalities, then comes the Miller, the second hurdle, that is the inquiries, right? The first things is that Miller, he has to proceed with an applications pursuant to that vacancies. There is no vacancy. So he is pressing today a dead case when he has coming up with the plea that I could not make an applications. Right? This is the fundamental things of the Miller, the FPS vacancies. Once the vacancy is being declared, he has to make an application. Even though today the point is that division bench granted the opportunity. You file in the meantime. He could not. Now, what remains? Had it been a case, this was filed, the officers or the authority was in a position to consider. But there is no application has been filed within the time. So thereby, Miller, kindly consider the moment for a moment. There is nothing in record. Until and unless that order is modified or otherwise set aside by the other courts or the higher courts or the same courts, we cannot proceed it, because lordship kindly take trouble to see once more Miller D page 51 and 52 once more. Miller 51 which my learned friend relies upon 234 is the Miller submission. Kindly do not go by that. Lordship kindly come to the page 52 state act. I am reading it. In view thereof, we dispose of the appeal with observation if the petitioner is eligible to apply and the vacancy still exists in terms of the memo dated 9th of August 2023 as disclosed on the application of the petitioner, if filed in meantime, may be considered. So, Miller, there are three things in this order. First, he has to be eligible for the apply. Second thing is the vacancy has to be exist. Third is that Miller, he has to apply within the meantime. There is a time limit has been set out by the revision bench. Today, Miller, there is nothing wrong passing this order by saying that, which is at page 63. Lordship, kindly take trouble to see.
Yes.
Now, when this has been communicated to Mr. Maiti, passed by the order passed by the subdivisional controller, consideration of the prayer of such and such, dated mat number such and such. With reference to the above, this is to inform you that the Honorable Judge such and such of the High Court have passed an order stating that in view thereof, we dispose of the appeal with the observation that if the petitioner is eligible to apply and the vacancy still exists in the terms of the memo dated 9th August as disclosed in the page 32 of the application, the application of the petitioner, if filed in the meantime, may be considered. It is mentioned here that the vacancy in this regard has already declared by this office memo dated such and such, and the last date of the application against this vacancy was 18th September 2023. But as per available office record, it is found that the Manoranjan Das led your client did not apply either online or offline of this vacancy notification within the stipulated time period. Milord, what remains, I'm asking myself. Milord, and this vacancy is basically widely circulated one. It is coming in the Milord newspaper as well as the website everywhere. There is no hide and seek here. Now today Milord, he knowing everything, he has annexed everything. He knows Milord, he could not Milord file the Milord the application, which is the basic criteria to get the Milord the dealership license. He failed. And Lordship kindly also consider one thing. Earlier, he was granted a license. He of by own gave up that right by saying that no, my health is not permitting, therefore I am surrendering the same. He has gave up his right. Then once again he suddenly wake up from the deep slumber and saying, no, I have to get the right back.
That question already.
That is not the Milord, he cannot. Here, Milord, the first thing is that this kind of petition we may be called as the mercy petition, but even though the division bench order is standing in the way. There is no vacancy, first of all, and the vacancy, even though declared, he has not applied. So thereby, his right cannot be Milord accrued. Once the application has been made, on that event, the right has been accrued. No right has been accrued. He was sitting tight over the issues. He could not make the application. Then coming over this court and saying that kindly consider. Milord, consideration cannot be done in automatically.
Okay. Lord, the only one investment, kindly appreciate to that. Just Lordship drawing attention, page 51.
Yes.
Lord, again, I'm drawing Lordship's attention, paragraph 3. Just Lordship drawing.
Yes.
Learned counsel for the appellant submitted that in view of the pendency of the appeal, no application was filed. That is admitted position. Second, next paragraph. This was not the same before the single bench. When single bench, that issue was not raised. This was first time raised, that the application was not time within the time, as because they have memo has mentioned before the division bench. So my responsible submission in this case, my lord, the purpose or intention of the division bench order, if the vacancy is still in force, if not filled up, if the petitioner make the application, admittedly petitioner could not admit the application. If the petitioner made the application, immediately after the division bench order, my client made the application that is received by the authority. So my responsible submission, my entitlement is not only the application, entitlement, well, other qualification is there also. The Lordship says, rightly held that the entitlement cannot be only for point of limitation for making the application. This application had been recorded. Division bench already in the record. My client could not yet make the application. That question cannot be re-agitated. When comply with the order of the division bench, that should be looked into the matter in terms of the court's order. My client made the application for bona fide. That is the exceptional circumstances which has been raised herein and which has been made before the concerned authority. This is not the similar way by way of notification. My client is the exceptional circumstances by the pending proceedings. My client could not make the application. That has been recorded. That has been submitted before the division bench. Division bench considering all the things, the passed in order. And the concerned authority, when disposing of the application, in comply with the order of the division bench. My responsible submission, this notice, my lord, without considering the fact, my client made the application not online, but this offline, since online already off, the offline application, that should be considered in application. And your lordship just pointing out that the limitation has not been condoned. Division bench also held that question was not raised before the single bench. So my lords, my lord, the hearing lords has the enough power to deal with this matter.
Very well. Please take down.
And my lord, the postman still existing vacancy still.
The instant writ petition was preferred for setting aside stroke was the order dated 6/5/2024 passed by the subdivisional controller within bracket F and S, Kapdip, South 24 Parganas. Full stop. Learned advocate for the petitioner submits that the petitioner was initially MR dealer for the area of Indrapur,
Mauja.
Indrapur. Full stop. Due to the ill health, he surrendered his dealership
In 2007.
which was tagged with the another MR dealer.
That is continuing.
The said license was continuing. Full stop. After recovering, next part, after recovering from his physical ailments, the petitioner filed a specific application for
Renewal.
granting fresh license
For renewal.
for
Renewal.
renewal.
Fresh up
Agree, agree.
has to be.
Agree.
I have not disturbed you while you are doing. Let me make my submission. That has to be considered as a fresh. Once it has been milled.
No, he submits that he was
that is
paid
prayer for
a
renewal.
revival of such a license like that.
That was
But
not
it has to be
considered.
considered according to the law as fresh license.
That's
For granting a fresh license with a prayer to revival of his earlier license. However, the authority concerned considered the application to be an application for fresh license and which was turned down, against which the writ application was preferred before the Honorable High Court. Subsequently, the notification for issuance of fresh license was cancelled by the notification of page. What is the notification? Which cancelled?
Page 47.
there is no notification.
Page 47.
No, you referred the page.
47.
I have referred below the new notification at page 48.
48. Yes. 48. কি বললাম বলো? No. Cancel the earlier memos by notification dated 17/8/2015 in terms of National Food Security Act 2013. Full stop. Consequently, the writ petitions was disposed of, against which the present petitioner preferred an appeal.
Yes.
Before the division bench of this court.
Subject to correction, it was dismissed.
It was dismissed.
It was dismissed.
Disposed of or dismissed. Writ petition was dismissed. Dismissed. Against which the present petitioner preferred an appeal before the Honorable Division Bench, wherein the Division Bench in WPA 4364 of 2022, no, in MAT 466 of 2021 has disposed of the appeal by passing an order dated 6 March 2024. Full stop. It is the submission of the present petitioner that by virtue of the order passed by the division bench on 6 March 2024, he preferred an application before the concerned authority offline, within bracket offline. Full stop. Such application of the concerned authority was not considered void and ordered by the impugned order dated 6/5/2024, against which the instant writ petition was preferred. Full stop. Next paragraph. Learned advocate for the petitioner submits that it has been ordered, it has been observed by the division bench of this court that the appellant could not file the specific application before the concerned authority in view of the pendency of the appeal. Full stop. The submission of the appellant was specifically noted by the division bench, and on the basis of the submission, the division bench had allowed the present petitioner to file specific application if the vacancy still exists. Mr. Moiti, learned advocate appearing on behalf of the petitioner, submits that the vacancy is still existing and the petitioner filed the application in view of the order passed by the Honorable Division Bench. He argued that the order passed by the Honorable Division was misinterpreted by the concerned authority, and his prayer was not considered only on the ground that the application was not filed within the stipulated date mentioned in the notification itself. Mr. Maiti further argued that the matter has already been considered by the Honorable Division Bench of this court, and the non-filing of the application is appearing in the order of the Division Bench. The Division Bench was sessile over the matter regarding the fact that no application was filed till the date of order passed by the Division Bench. In spite of that fact, the Division Bench has passed an favorable order in favor of the appellant that can be interpreted that the Honorable Division Bench has allowed the petitioner to file an application to the concerned authority, and the concerned authority is directed to consider the application if he is otherwise eligible. This is your submission.
Otherwise qualified.
Otherwise qualified, not eligible. Otherwise,
But qualification means not only the point of application. Qualification is other things is there.
I understand. No, the term is eligible, not qualified. Correct. Eligible. Full stop. Mr. Maiti further argued that the present petitioner was refrained from filing the specific application within the stipulated time due to the pendency of the instant appeal, due to the pendency of the appeal being met 466 of 2021. Thus, the order passed by the impugn order passed by the concerned authority is illegal in the eye of law. The present petitioner may be allowed to include his application in the said proceeding. And if the present petitioner appears to be eligible, otherwise eligible stroke qualified, otherwise the petitioner may be granted the license. Next one. Learned advocate appearing on behalf of the state submits that the issue for filing the application in respect of 9th August 2020, in respect of notification dated 9th August 2023, was not placed before the learned single bench. However, it was first It was first placed before the learned division bench. Full stop. He specifically read out the paragraph 4 and 5 of the order passed by the learned division bench and submits that the honorable division bench has specifically pointed out that if the petitioner filed an application in the meantime, that may be considered. It is the fact that the petitioner did not file the application within the stipulated date mentioned in the notification dated 9th August 2023. Thus, the authority has correctly passed the impugn order. Stop. He submits that the order passed by the division bench is crystal clear and it is unambiguous to explain that if the application is filed within the time, that can only be considered. So he submits that the authority concerned has not committed any error by passing the impugn order. Are the learned advocates peruse the observation of the honorable division bench in MAT 466 of 2021 on 6th of March 2024. Paragraph 2, 3, 4 and 5 is required to be set out for the proper determination of this matter. Paragraph 2, 3, 4 and 5. Set out. Set out. Assume code 2, 3, 4 and 5. 2, 3, 4, 5. It is the admitted position that the present petitioner was a EMA dealer and he had some experience regarding maintaining the license, regarding maintaining the fair price shop. Such experience of the petitioner cannot give him any weightage in respect of a specific application, in respect of a notification dated 9th August 2023, where fresh applications were called. It is also a fact that the present petitioner did not file the application within bracket online in terms in terms of the notification dated 9th August 2023.
Online as well as the offline. Lordship would find it on page 14 onwards.
Online, offline, both.
Both he has not filed. Lordship kindly take
Yes. Full stop. Already dicta. কি বললাম বলো first এ? হ্যাঁ 2023. The last date of application in terms of notification dated 9/8/2023 was 18/9/2023. Full stop. When the matter was heard by the Honorable Division Bench on March 2024, the date of filing application has already been expired. The same was argued before the Honorable Division Bench by the appellant stroke petitioner. After hearing the petitioner, the Honorable Division Bench allowed the present petitioner কি বলো? No. After hearing the present petitioner and also taking note of the submission of the state that if any application was filed by the petitioner within the meantime, that will be considered. The replica of the submission made by the state was mentioned unequivocally by the Honorable Division Bench to the effect that if the petitioner is eligible to apply the vacancy still exists in terms of memo dated 9th August 2023, comma, the application of the petitioner, if filed in the meantime, comma, may be, comma, if filed in the meantime, comma, may be considered. Full stop. Paragraph 5 of the impugned order passed by, paragraph 5 of the order passed by the division bench is very much clear regarding the fact that the eligibility of the petitioner to apply was never touched by the Honorable Division Bench. Full stop. Finally, full stop. Next paragraph. Next paragraph. Mr. Maiti further argued that the only point of limitation can be entertained by the instant read court in this read application. I make it clear that the point of limitation may be considered very leniently in terms of section 14 of Limitation Act, that if a person is proceeding otherwise in wrong forum, the time of limitation in proceeding in the wrong forum may be condoned, semicolon. But in this case, it appears to me that the order passed by the Honorable Division Bench is very distinct and clear. Considering the same, I find no justification to entertain the prayer of the present petitioner to pass any appropriate order. The petitioner may have his opportunity to have an order from the Honorable Division Bench regarding the clarification of the order passed in the appeal. The instant read court cannot interpret or clarify the order passed by a division bench. Considering the same, the instant read petition is disposed of. Stop. Next, as the affidavit in opposition is not called for, the allegation labeled in the read petition is not deemed to have been admitted.
Much appreciated.
Lordship, and for the petitioner, the matter was taken up yesterday, but your lordship fixed it to be appear on tomorrow. But due to some technical mistake, it has come up in today's list. It is supposed to be taken up tomorrow.
Tomorrow?
Yes, your lordship. Yesterday, your lordship fixed it for day after tomorrow.
Yeah,
It has
tomorrow I mentioned it
yes,
after tomorrow. Thank you, lordship. Okay, okay. Tomorrow, not today.
Obligation.
Grateful one.
Give me the- Okay, please take down. None appears on behalf of the parties. It appears that yesterday the matter was called for. The state represented, but the petitioner was absent. Considering the situation, it appears to me that the petitioner is not at all interested with the procedure of this matter. According to the instant writ petition,
Appearing for the petition. I have been asked to pay for one-day accommodation, but I forget to. Was this 13 is the matter? Mr. Samuel Bari asked me to pay for one-day accommodation.
কাটো, 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 পুরো অর্ডারটা কাটো। অর্ডারটা কেটে দাও। I am going to dismiss this matter.
I thought, it is not 13 that.
I called the matter yesterday.
Yes, your lordship called.
I called the matter yesterday. State submits that they have served the affidavit in opposition to the petitioner, but the petitioner is not turning up. What is the situation there? Okay, very well, not today.
Not today, only now.
Come on tomorrow, otherwise I will dispose of the matter.
Time for the Indian Oil Corporation, my lord.
You are appearing on behalf of the IOC. Please take down. None appears on behalf of the petitioner. The matter is running in the list. The IOCL is represented by learned advocate. What's your name?
Ashwati Chatterjee.
Mrs. Saswati Chatterjee. Considering the situation, the petitioner is awarded a last opportunity to represent. Let the matter be appear on the list on the next week. Please take down. None appears on behalf of the petitioner. The matter is running in the list. The petitioner did not comply the order passed by this court regarding filing exception to the report of the state. Considering the situation, it appears to me that the petitioner is not at all interested to proceed with this matter. Accordingly, the instant writ petition is dismissed for default. Any interim order passed by this court on the earlier occasion is hereby vacated.
My lord, I beg to have on the stay respondent one.
My lord,
I am appearing on behalf of the tribal.
My lord, I am praying for 2 weeks adjournment, my lord. Affidavit in opposition has been filed by the state, but a reply has not been made ready, my lord. My client is ill, my lord.
I hand it over this.
Yes, my lord. I am praying for 2 weeks adjournment, my lord. State has filed the affidavit in opposition and handed over to me, my lord.
That my only prayer to comply the division bench judgment. এটা কি আপনার?
Who is appearing for the private
No, no, no.
respondent?
I am.
You are appearing.
Yes. I pay only to comply
You
the
yesterday submitted.
না না আব্দুল
আচ্ছা।
বাব আপনি বার
my lord. Sorry, my lord.
You are not in this matter?
No, my lord.
Okay.
Sorry,
I
my lord.
understand.
খালি yesterday হলো
Yes, that's why yesterday you have submitted that the matter was already disposed of by the division bench, directing to the fact that the private respondent may be given opportunity if the mother of the private respondent died. This is the case.
Yes.
But the petitioner is not turning up.
This is submission before the last.
Who is for the state?
I
for the state.
already
Please take
filed my
down.
report, my lord.
Yes. Please take down. The none appears on behalf of the petitioner on call. State is represented. It has already been considered by this court that the private opposite party was given opportunity by the division bench that his prayer for issuance of license would be considered by the authority in absence after the demise of the mother of the petitioner stroke private respondent. Learned advocate appearing on behalf of the private respondent submits that the same direction may be passed in this, may be passed by this court. Stop. It appears that the petitioner is not representing, thus representing the, considering the situation, it appears to me that the petitioner is not at all interested to proceed with this matter. According to the instant writ petition is disposed of. According to the instant writ petition, it's dismissed for default. Full stop. Any interim order passed by this court on the earlier occasion is hereby vacated. Stop. I make it clear that I have not entered into the merit of this case. However, the respondent state authority is at liberty to proceed with this matter, proceed with the issuance of license
In accordance with law, my
in
lord.
accordance with the law.
Grateful, my lord.
My lord, my matter is item number 16. My junior has given a wrong item number, my lord. I am present here, my lord. Item 16, Nikhil Kundu, my lord.
Item 16, my lord. Mr.
My
Shishant
lord,
Bandapal.
in this matter, I am praying for adjournment, my lord. I am here, my lord.
Item number 16,
16, 16.
dismissed for default.
Before, my lord, I am present here, my.
You are sitting there.
Yes, my lord. My junior has given wrong number, my lord. Item 18. My lord, I am praying an apology, my lord.
Give me the paper. Give me the papers. You were sitting there and your matter
Yes,
was
my lord.
called, make mom. Make yourself mom. So what can be done?
Affidavit is complete.
Ah.
But affidavits have been exchanged in this matter.
Excellent, my lord. My lord. Reply has
The
not
matter
been
is that,
met.
the petition, name of the petitioner is Nikhil
Nikhil Kundu, yes, my lord, Nikhil Kundu. I am appearing on behalf of the petitioner.
Okay.
On earlier occasion also I am appearing.
Item number 16. No, देखो. So affidavit in opposition has been filed on behalf of the state.
Yes.
Report, we have filed a report.
You file a report.
Report.
So what you want to file exception?
Yes, yes, my lord.
Then file it.
Yes, my lord. I'm praying for 2 weeks adjournment. In the meantime, I shall file, sir.
First week of July.
Yes, my lord. Grateful, my lord.
Grateful.
Next.
I am for the petitioner, my lord. Petitioner. Or I am filing my affidavit in reply to the opposition filed by the respondent number 9, that private response.
Let state also filed an opposition.
State filed a report, I think so.
Mhm.
They filed report. And I have already filed my exception there. Or kindly come to order dated 29th of March,
Is appearing for the state.
Mr. T.M. Siddiqui
State is very much
with
required.
Tutanu Chakraborty.
Well, action of the state is under challenge. State is required because they have also filed the report in the.
Yes, I have used my exception to that. Malad, let me place my case in nutshell because a report is to be required, Malad, and investigation is to be required. Malad, 29th of March 2023, kindly have a look to the order passed by this court in this writ petition.
29th of
March 2023, in this writ petition.
29th of March. Yes.
Learned counsel appearing on behalf of the petitioner submits as follows. The respondent number 9 who was granted the dealership was not a local resident. Moreover, his mother-in-law was a fair price shop dealer.
Yes.
Your lordship knows if any relative of an applicant is holding this dealership, he is not eligible for the post.
Mother-in-law, whether coming under the.
Yes, yes, yes.
That is after 20.
Yes, and this is process of 2022.
This
The process is of 2022. I will show. Please don't mislead this court. Don't mislead this court.
Let me hear that. Let me hear the matter. Thereafter, I will
Yes.
hear it.
Now, after this, my lord, your lordship kindly, second paragraph, learned counsel appearing on behalf of the private respondent denies such allegations and prays for liberty to file opposition. Learned counsel for the state submits that state would be in position to file a report in this regard. Now, state, my lord, they have used a report. What they say, the petitioner failed to supply any document towards his claim that the mother-in-law of respondent number 9 is a dealer. That's their stand. Now, private respondent used an affidavit in opposition. He said that there is no relation with the another private respondent whom I have, my lord, added, claiming as his mother-in-law. He said, I have no relation with him. If that is the so, then this writ petition fails. But I have used my opposition, my lord, reply, kindly come to my reply. Why I said a thorough inquiry is required in this matter. Kindly come to page 6. Prior to that, my lord, I must say something that this person, he has 2 wives. He dealt with one whose mother is not a dealer, but he suppressed existence of another. That I have disclosed, page 6. There your lordship will get Bongsho Talika.
Majed Mondol at the top. Left hand side, Mrito Abdul Mojid Mondol. Now, his wife or widow is Sri Ferdosi Bewa, bottom, left hand side, and right hand side, Arifa Khatun May. So, Arifa Khatun is the daughter of Ferdosi Bewa. Your Lordship got it?
Okay. So the wife of Abdul Majid Mandal is Firdosi
Firdosi.
Bewa, and the
Arifa Khatun is
son,
the daughter.
Abdul Hakim Mandal is the son of Abdul Majid Mandal,
Yes.
and
Arifa Khatun,
Khatun is the daughter.
and her husband's name is below Shariful Islam,
Yes.
the private respondent number 9 here. Now kindly come to
Sariful Islam is the private respondent number 9.
Now
Okay.
kindly come to the next page. Bongsho Talika. Now left hand side Shariful Islam. He is the son of Jakir Muhammad Bishas at top. Now he has two wives. One is Nargis Bibi Prothom Istri, and right hand side Arifa Khatun Dityo Istri. Now my claim is this, that Arifa's mother Firdosi, she is the dealership holder. And the report of the state is silent on that. I would be beseeching with your lordship, kindly allow me to add the district magistrate as a party respondent. Let there be a direction upon the DM to conduct an inquiry and apprise this court regarding genuinity of this.
Before that, my lord, may I submit?
And I have annexed
Your submission is Sariful Islam has two
wives.
Two wives.
Yes.
One is Nargis,
Nargis
and second is Arifa.
Arifa.
He disclosed that Nargis is his only
Yes.
wife.
He suppressed Arifa.
You say that Arifa is also his wife.
And Arifa's mother
Arifa's
Firdosi,
Firdosi
he is the dealer.
having
She is
a
the dealer.
license.
Yes, ma'am.
But that was not disclosed by the state.
No. State says,
Since there was
state says these petitioners failed to supply any documentary evidence.
Documentary evidence.
Evidence
regarding
towards my
the-
claim.
Regarding the
They have no duty to conduct any inquiry because they are otherwise supporting the private respondent. If I am permitted to show your lordship my contention, kindly takes up come to page 3 of my reply. Page 3, my lord, may I read it for second paragraph? In this connection, I further say that the respondent number 9 in this affidavit, in his affidavit in opposition, has made drastic attempt to practice fraud upon this honorable court by suppressing the facts of existence of his two wives and producing documents in respect of only first wife to show that her mother, that is the mother-in-law of the respondent number 9, doesn't have any dealership. While Firdosi Bewa, mother of Arifa Khatun, is the existing MR dealer of her nearby area. Next, I further say that from the electoral roll of Raipur Gram Panchayat, it appears that name of respondent number 9 has duly been furnished against serial number 354 of part number 215. Or may I show your lordship page 21? Kindly come to page 21, my lord. I have annexed that electoral roll. From bottom third row, right hand side. Serial number is 354. All got it? Serial number 354, Muhammad Shariful Islam.
Yes.
Now I will kindly come to
Where is the electoral roll of Arifa Khatu?
yes, I will show. I'll kindly come to 156. I'll kindly come to page 15.
15.
15. The serial number is 156. From top, second, right hand side. Arifa Khatun, Shamin Nam, Muhammad Shariful Islam. The second row, right hand side. And if your lordships allow me, I will show another page only. Serial number 394. Serial number 394 at page 23. P94, that's my lord, second row. First one, Nargis Bibi, wife of Muhammad Shariful Islam. Now kindly allow me to add the district magistrate as a party. Let him conduct an inquiry and apprise this court regarding status of this. If
My lord, may I
that's the fact, then he has to out. If that's not the fact, my lord, cost must be imposed upon me.
Yes, what is your submission?
My lord, your lordship, in so far the wife is concerned, my lord, that is absolutely out and out false and fabricated. These documents, how could he procured, my lord, that is doubtful. I will produce the original certified copy of the list of voter list. I will produce it. In the village, there may have 3-4 Shariful Islams. There may have different wives,
Yes.
but in the present case, what is the report of the state, your lordship kindly? There are 2 points, 2 grounds in the writ petition. One is, I am the outsider. Second is, I am having wife who is relative
Whose mother is
whose mother is dealer.
having a dealership.
That is the second point. Now, this point come, whether mother, my lord's wife, mother is
A dealer.
a dealer, will come under the bar in terms of, my lord, notification 2020. Though this he is not my wife, but assuming if she is my wife, then also this notification of 2020 will not come into play in this matter. Your lordship, kindly come to page 2 of the report filed by the state.
Affirmed by one Musir Ahmed.
Yes, got it.
My lord, last paragraph, my lord, 3A.
Paragraph
3A.
3A.
The Department of Food and Supply are of the view that it is essential to have a fair price shop at the earlier enclaves or Khidirpara. Accordingly, memo number such and such dated, this is very vital, 12/2/2019 was issued notifying the fair price shop vacancy in Khidirpara of subdivision Domkal, but no applicant was found eligible for fair price shop. In this notification also, I applied. Nobody was eligible. Then, thereafter, after obtaining approval from the district magistrate, a forwarding letter bearing memo number such and such dated 23rd February 2022, issued by District Controller Food and Supply, the Subdivisional Controller Food and Supply, Domkal, issued re-notification. That is the continuation of the earlier notification. Through vacancy online module in accordance with the memo number 2012 memo. Therefore, vacancy of 2019, notification issued in 2019, that could not be filled up because of non-availability of eligible candidates. While I also participated, my godown was not permissible according to the law. Subsequently, I modified it. Re-notification, that notification, continuation of that notification of 2019. Criteria was same as of 2019. I participated along with so many others. There were 5 applicants. After considering the credentials and all other criteria, I was selected. This is one part. Insofar as the report file, my lord, the table issued by the Pradhan, my lord, I will ask, request your lordship to ask this Pradhan to be present before you. Let him come and explain how he could write this Vangsho Talika. Let him come and explain whether he has signed it or not.
Then again one inquiry, again another inquiry.
This Pradhan has to come.
Sufficiency.
Only one day this
No, no.
Pradhan has to come and say before your lordship that this signature is of mine.
The MR section of DM is sufficient to determine the ARC for everything.
Yes. Let the
This is
DM.
the section
Very well.
under the DM.
Refer this
Which
matter
can-
to the DM to decide.
Yes.
Let him decide.
Let it be
entire
decided
issue.
otherwise. Okay.
Lordship, direct them.
Before going to the merit of this matter, let the question be answered positively or negatively, whatever may be. Thereafter,
Yes,
the
the entire matter be
And my
placed
lord,
before
may
the
I,
district magistrate.
my lord, in reply to my
Let him
landed
take a
friend, may I say
decision.
one thing?
Let him take a
My
decision.
landed friend, my lord, produced, my lord, read out only one paragraph.
I don't have the
Yes,
opportunity.
from the report, which says they have followed 2022.
No,
Well,
let me
let-
pass
Yes,
the
ma'am.
matter.
Yes, ma'am.
Well, I do not have the opportunity to place the hotel list by which my name and the Arifa's hotel list, which is sought to be.
Whether it is required to make the DM party, otherwise a specific.
no, your lordship
selection may pass.
Your
Your
lordship,
lordship
But
can
the
pass
DM
on. Yes, yes.
DM can hear out the matter in
And decide.
presence of both the parties.
Yours.
and let him place the report before lordship.
Yes.
এখানে কেন?
Yes.
Let the
But
DM
no,
decide.
final
Entire.
legal is to be
Let
taken.
it be
DM
disposed
is
of.
not the authority to decide all these things.
Report আর দরকার নেই। Report তো subdivision
The
controller
report is to be placed before
report
this
of
court
the
by the DM.
state is before your
Whether
lordship.
he is,
I understand.
Let the DM decide the entire issue
No,
and pass a
DI
result order.
cannot. DM cannot. DM will decide this allegation and place this matter before lordship.
District controller is the authority.
No,
District controller is
the persons, my lord, who will inquire regarding his selection.
the
But
authority.
the allegation,
I have heard.
Yes, ma'am.
I
Yes.
understand the issue.
Yes.
You just help me to passing the order.
Great.
Please take down.
হুম। Inquiry, ঠিক আছে, তাতেও হবে। হুম, হুম। না, না, এটা আমার বই না। কোথায় থেকে কি কাগজ জোগাড় করে নিয়ে চলে এসেছে? ওদের হয় নাকি?
What is the name of respondent number 9?
Yes.
Shariful, ma'am.
Sariful Islam,
Yes, ma'am.
son of Zakir Muhammad Biswas.
Yes.
Okay. Instant writ petition was prepared by the petitioner challenging the issuance of MR dealership license in favor of private respondent number 9, namely Sariful Islam, son of Zakir Muhammad Biswas, residing at village, দেখেন নেবেন, respondent number 9, পুরো অ্যাড্রেসটা পুরো হচ্ছে during the pendency of the instant writ petition, one issue was raised before this court that the mother-in-law of respondent number 9 was a fair price shop dealer.
My lord, mother-in-law has been made party as respondent number 10.
Full stop. The mother-in-law of the respondent number 9 was made a party of this writ petition, being respondent number 10.
Yes, ma'am.
Namely, full stop.
Firdosi Bewa.
The report of the state was filed in terms of the direction of this court by the, who filed the report?
On
The
one,
sub-divisional controller,
yes,
namely Mushi Ram.
Sub-divisional controller. Where is the report?
Dome call.
Let me take out the report. Okay.
Sub-divisional controller, food and supply, Dome call office.
Sub-divisional controller, food and supply,
Dome call.
dome call. Full stop. কি বললাম? Report. Dome call, which doesn't disclose regarding the fact that whether the mother-in-law, whether the respondent number 10 is the mother-in-law of respondent number 9 or not. Full stop. Exception to the report was filed in form of affidavit by the petitioner containing inter alia the list of
But that I have filed, my lord.
He has not filed
In
an
the,
exception
no,
to the report of the
exception
state.
that I have filed, exception that I have filed.
Exception to the
But that
report of
point
the
I have
state
taken in the
has not been
reply. Exception দেওয়া আছে, দাদা
this is
কেন
reply.
That's reply to the respondent number 9's affidavit.
Nines, not
কি বললাম?
of the state.
Exception আছে, দেখো না, কেন বলবো?
Exception affidavit in reply
তোমার কাছে
on
notice
behalf of
আছে?
the petitioner was filed against the affidavit in opposition of respondent number 9
Yes.
containing inter alia the electoral list
Yes, ma'am.
of 75 dome call general within bracket answer ANSH answer 215. Full stop. Next, learned advocate for the petitioner pointed out the name of the persons appearing under the same legislative constituency wherein the two lady, namely Nargis Bibi and Arifa Khatun, having named their husband's name as Sariful Islam.
আমি জানি না, আমি
Full
দেখছি
stop.
না, আমি আশা করি তোমাকে দেওয়া, কিন্তু তোমাকে দিতে বাধ্য নয় এটা।
The contention of the petitioner was heavily objected by the respondent number 9, containing arguing inter alia that there may have several persons named Shabiul, named Sariful in the said legislative constituency. Next part. It appears to me that the matter can only be decided by a specific report of the concerned district magistrate. South 24 Parganas?
No,
No, Murshidabad.
the Murshidabad.
Murshidabad. Murshidabad. At this juncture, before disposing of the instant writ petition, the report of the DM Murshidabad is required to be placed. Thus, it is ordered that the district magistrate Murshidabad is directed to conduct an inquiry regarding the fact that whether the present respondent number 10 is the mother-in-law of respondent number 9
or not.
full stop. The or not. The DM shall submit a report after conducting a detailed inquiry in presence of the parties.
Lordship.
Stop. Before initiating the proceeding, the district magistrate shall hear out the parties by issuing a specific notice upon the parties. Full stop. The DM, the concerned DM, shall conclude the exercise and submit a report within 8 weeks.
And your lordship kindly direct the DM to consider the submission of the Pradhan also. Let him be with the DM.
No,
He is the
DM
mischief maker.
No,
This Pradhan-
DM is not influenced by anyone. DM has his explicit
No,
authority.
The
Exclusive department, MR department like that
the
is there.
Bongsho Talika, the
No, that is the separate issue.
that has been
Whether-
issued by
whether
the
he has-
Pradhan.
Whether
On that strength, the inquiry is being conducted.
Let us come on the next
Let
day.
him be also
Receive the
crossed.
let the report be come. If the
Yes.
report is come in your favor, then
Then he would be on track.
He
then
is
he
not
is not
correct.
Definitely.
But that Pradhan should be punished.
Yes.
that is
Not only the
separate issue.
Pradhan, but also the
Let the
petitioner.
report be come, so that the Pradhan may not influence the DM.
Yes, ma'am.
Okay.
He's
DM may be inquired independent.
well, the voter list, I don't mind, but there may have several voter lists,
I understand.
several names.
Yes, yes.
But how this Pradhan could
Let it be proved before this court.
Within 8 weeks.
Yes, ma'am. Can you fix any date, my lord?
Let the matter appear in the list on
October for us.
3rd week of August.
Great, my lord. But one thing, my lord, that report should be filed by the DM through the learned, because today's state advocate is not appearing. So kindly, my lord.
Let the instant order be served upon the concerned district magistrate Murshidabad through the office of the Learned Registrar General High Court, Calcutta.
Great, my lord. And that report should be filed through the my lord, Registrar General.
Can
Yes, county.
State
to
advocate
state
will
to
be
ask-
representing how?
No,
Well,
state-
we could
yes, sir.
apprehend that
Yes.
he will not be present.
Great.
Good. নামটা লাগবে? উনি জানেন না নামটা আমার?
My lord, I beg to have on stage. No, respondent. Only private respondent? Private.
My lord, kindly see the order dated 1st May 2023.
That is also case while Pradhan issues a fake certificate.
On the basis of that, my lord,
One report was called for.
Yes, my lord,
Yolongi had submitted a report.
already, yes, already filed.
Who is for the petitioner?
my lord, I am for the private respondent.
Who is for the petitioner?
Petitioner, my
Is
lord,
absent.
yes, is absent, she's absent.
Mr. Kingsuk Mondo.
Kingsuk Mondal. Last occasion, he's appeared before.
Yes.
Pradhan says that
Whether
you are not issued
whether
any
the
certificate.
petitioner filed exception? Whether
Yes.
My lord, I have not.
Pleadings are over. Exceptions, reports, pleadings are over.
he was directed to file an exception.
Yes.
Whether he has filed
They
exception,
served a copy of the exception to me.
you received the exception.
Yes.
But the exception was not filed in this.
Oh.
Let it appear in the next week.
My lord, I have not received the report, my lord. I have
At
not
the point of time, he is not appearing, my lord. Private respondent is not appearing
You are the private
point of time.
respondent.
number 9.
He perhaps in first time.
Let the petitioner become.
It's a,
You are the first time
the
appearing.
first time appearing, my lord.
Then an order is required. Please take down.
My lord, report may be
Let the petitioner become. Thereafter, he will serve the report. I will serve the report. I will show the
Because
report.
report filed by the state and the exceptional filed by
Report
the
filed by
private
the OC.
OC, and also previously there's an report of the SCFS, my lord, subdivisional controller. That also record, my lord. Then the
You are
OC.
the respondent number, private respondent number 9. Private respondent number 9 is represented by learned advocate. Your name, please.
Yusuf Ali Dewan.
Yusuf Ali. Dewan. Full stop.
Petitioners related documents from the Pradhan certificate that was claiming there's a fake certificate.
That document is manufactured.
Manufactured document.
State is represented. Full stop. None appear on behalf of the petitioner. Learned advocate appearing on behalf of the private respondent submits that a copy of the report filed by the officer in charge Jalongi police station may be served upon him. Have you received the petition? The writ petition?
I have received the
You have received the writ petition. Do you want to file any objection? Affidavit in objection?
আমারটা নিয়ে আমরা তো কিছু পারপাস সার্ভ করবেন that is on the basis of the petitioners, but if he separately filed one objections he can file. আমি আপনাকে দেবো, বাট হ্যাঁ ঠিক আছে।
One report of OC, Jalongi
Jalongi.
PS, and another
Another, my lord, in report in the form of affidavit filed by the subdivisional controller, Dome call
report
report.
by respondent number 7.
Yes, my lord. The
And
subdivisional control Dome call.
Anything?
I have two documents, my lord.
Only 2 documents are there.
Reply to the report filed by the petitioners.
No, it has not filed in this.
Yeah, copy has been
Yes,
served
you
to
have.
me,
Okay.
but that is not on record.
কি বললাম বলুন লাস্টে as the petitioner is not representing today, so the instant matter be listed next week for further consideration. The report as asked for by the private respondent will be served after hearing the petition. The private respondent number 9 is at liberty to file affidavit in opposition within the adjourned date.
Grateful,
Next
man.
week. Let it appear after 2 weeks.
Grateful, man.
2 weeks. Next.
My lord, in item number 21, Mr. Suman Sengupta and Mr. Sambhuta Datta are appearing on behalf of state.
I
my lord.
appear for the.
And in this matter, my lord, there was a direction to file a report by state, my lord. That report has not been prepared. So,
No,
Mr.
report
Datta-
filed.
report has
Yes, it is served upon me.
an advance copy. It has not yet been, my lord, affirmed. My lord, we are seeking for 1 week time. My lord, Mr. Datta has requested me to pray before your lordship for 1 more week for filing this report, my lord. Lord, that is what Mr. Datta has requested me.
Reported.
Okay, very well. Next week. Come on, next week.
My lord,
You have got the advance copy.
I have got the copy and I have prepared my exception to the report also.
You just wait. Let him file in court the report, affidavit in opposition. Thereafter, I will file. Next week.
Report দিয়ে দিয়েছে আমার। প্রদ্যুৎ কুমার দাস।
22, I am for the petitioner, my lord. Although I am filing the affidavit in reply, my lord, to the affidavit in opposition filed on behalf of the state. My lord, but some documents which are required by me from my client for production before your lordship are not coming due to his illness. So that I am praying before your lordship to adjourn this matter for the next week,
Then why
so
you
that I
filing
may
the
be ready.
Why are you filing the reply?
Reply.
Why are you filing the reply?
Well,
File the documents with the reply.
Oh yes, my lord.
that is
That
the
may
better.
be.
That is a better man.
Come on next week. Next week?
My lord.
Okay, not
Next
this
week.
Great.
Stated.
In this matter, on last few occasions, petitioners have not appeared.
Several adjournments have been sought, my lord. We have filed a report on behalf of state. My lord,
Absence of petitioner, the dismissed or default.
আমি দেখে নিচ্ছি।
So who is for the petitioner?
They are not represented, my lord, and they have taken
All day.
adjournments on previous occasions as well.
Probably possibly they are not interested. Because we have exchanged our affidavit. Now it is very clear to them that there is no case.
Okay, please take down. State is represented. The respondent number 4 or 6. The respondent of 6 is also represented. None appears on behalf of the petitioner. It appears that the affidavits have been exchanged between the parties.
Lord, we have filed a report. We are yet to receive any exception from the petitioner.
Okay. Okay. No, Kadunta. Affidavit of the state has already filed a report, but the
As well as 6.
state is respondent number 6. No?
The private respondent and state both have filed their affidavits. my lord.
Okay. The state has filed a report. Okay, then? State has filed a report, but no exception has been filed by the petitioner. Considering the situation and considering the absence of the petitioner, the matter is adjourned for this day for passing a necessary order tomorrow.
But I have also filed an affidavit and record that.
At least.
But at number 24, my lord, I am for the petitioner, my lord. In this, in this matter, my lord, we have challenged the vacancy declaration notice on the ground that there is a promulgation of 2015 central control. An interim order has been passed and interim order is subsisting. And now the identical matter is made CAB. What I am praying, let the matter go out of the list for the time being. Thereafter, if any situation arises,
I
You are appearing on behalf of the-
appear for the private respondent, my lord. I have made an application, my lord, for addition of party. It was subsequently allowed, my lord, and the honorable court was pleased to direct me to file the affidavit in opposition, my lord. And I have received the copy of the brief, my lord. Only I am praying, my lord, the time to file the opposition be extended, because in the event, my lord, it is needed, my lord, to assist your lordship, my lord, kindly extend the, my lord, time to file the opposition, my lord. This is one submission. And the other one is, my lord, since there is a stay, my lord, in a similar case, my lord, a particular, my lord, distributor, just like me, has been awarded with the, my lord, license, my lord. May the license be issued in my favor, subject to the result of the writ petition. এই তো কি বাগমুন্ডা না কি একটা আছে
চ্যালেঞ্জ করা হয়েছিল নাকি?
হ্যাঁ
ভ্যাকেন্সি চ্যালেঞ্জ করা হয়েছিল?
হ্যাঁ
কে করেছে?
তুমি করনি অন্য লোক
কে করেছিল? আমি তো করি।
specified, my lord, where, my lord, a distributor similarly situated like that of me, my lord,
There
has
is a
been given
subsisting
the license.
interim order all through.
May I please?
Interim order দেখি দাঁড়া।
Subsequently withdraw.
And now you wanting to vacate the interim order?
Without any application for vacating.
My lord, I understand, my lord, there is an application, interim
No,
order
no,
is there, my lord.
that will be considered after passing the order, which were made CAB. Okay.
Yes, my lord. Yes, my lord.
Well,
Will the matter go out of the list?
Yes, my lord.
Please take down.
My lord, item 24 is also, my lord,
24 ই তো হচ্ছে।
27, my lord.
একটা করে।
Let me pass the order 24.
Yes, my lord.
You are respondent number
But I am the respondent number, my lord, 7, my lord. The private respondent, my lord.
Have you filed the affidavit in opposition?
No, my lord, that is the reason, my lord, I am seeking time for extension, my lord, to file the opposition, my lord. হ্যাঁ দিচ্ছি I am, my lord, respondent number 7, Qazi Fazle Rahim.
আচ্ছা private respondent number 7 seeks accommodation to file affidavit in opposition. Stop. Next paragraph. Learned advocate the petitioner submits that the identical matter was pending before the is under consideration, under active consideration of this court. So the matter may go out of the list. Considering the submissions, the matter be adjourned today. Release the matter after 8 weeks. After 8 weeks.
After
My lord.
'25, I am appearing for the petitioner, my lord. My lord, petitioner died. My lord, already substitution application has been filed, my lord. But I am not searching out the copy of the substitution application.
Can number?
Can is 1 of 2024. Even I could not serve the copy of to the learned advocate.
To serve it. Come on next week.
My lord, next week.
Not this week.
Not
Great,
this
great, great.
week. 26, my lord, I am for the respondent number 4. Private respondent.
My lord, item 26, I am for the petition.
You are for the petitioner.
Yes.
I beg to leave to file my affidavit in opposition.
My lord, I am filing copy of exception filed by the state.
Reply.
My lord, yes, my lord. Exception to the report submitted by the state, my lord. Kindly see the order
Okay,
dated, my lord,
exception to the report.
Yes, my lord. 26th July 2023, my lord, kindly see. Order dated 26th.
Which for the state? Mrs. Sangita Roy.
Sangita Roy is for the state, my lord.
রিপোর্ট দিয়েছে নাকি?
রিপোর্টটা দিয়েছি। রিপোর্ট আপনাকে বোধহয় আপনি অ্যাপিয়ার করেননি তখন।
আচ্ছা আচ্ছা।
Where the state filed report?
State filed, my lord.
Where is the
I
report?
received the report, my lord, and filed the exception, my lord, against the report filed by the state. But I think state report is not. My lord, may I submit one thing, my lord? My lord, I received the affidavit filed by the private respondent, my lord. I want to file reply, my lord. 1 week time may be granted. In the meantime, my lord.
Okay, just wait. Wait for a while.
My exception is
রিপোর্ট ফাইল করেছে বলছে রিপোর্ট করছে। I'm not finding any report. Please help me.
Milord, I think Milord,
No report is there.
second occasion Milord,
না হয়তো রিপোর্টটা এখানে ফাইল করেনি
state file করে।
হ্যাঁ
Milord, I think state did not file a report, Milord, report with him or with her, Milord.
No report is there.
But the report was
Is served
submitted.
is served a copy
They
of
may
that
be
court
served, but the report is not in the record.
has not
So
yet
what can be
filed in
done?
the court.
No, who is appear, Mr.
I received the report.
Okay, okay. You
Advance.
keep it with you. It is your copy.
This is my affidavit in opposition. I am now just
Okay.
filed a-
So you want to file reply.
Reply against the opposition filed by the private respondent.
Okay, please take down. Affidavit in opposition file on behalf of the private respondent number 4 is taken on record. Full stop. You take back the exception. Let the report be filed thereafter exception. The petitioner seeks liberty, seeks a leave to file affidavit and reply against the affidavit of opposition. Let the reply be filed by the petitioner within 2 weeks. Let the
Milord, fix the matter, Milord. Milord, fix the matter, Milord.
let the matter appear in the list on first week of July.
And let fix the date, Milord. Otherwise, Milord, it will be again fix the date.
Fixing date would be otherwise.
After 2 weeks, any date, Milord. Any date, Milord.
State is not there. That is
We can have a
difficulty. State is not there. Otherwise, I will fix the date. State is not there.
I shall inform.
Very. Come on, 4th of July.
4th of April. Grateful day.
4th of July.
Grateful day.
Lordship, in 27, my lord. And in 27, my lord, we had made an application for addition of party. Our application was allowed, but we are yet to receive the amended copy of the writ petition because we have to file an opposition to the writ petition. And if only one prior, my lord, that,
Private respondent number.
and I don't know whether I've been implicated in the writ petition or not. I've come up with an application for addition of party. My application was allowed. And I don't know whether the impediment has
And
been
one
carried
is
on.
the addition of party.
Yes, my lord. And I am not aware whether the impediment has been carried out in the writ petition or not. यही है वो देखें ठीक है appearing for Hashibur Rahman, my lord, he had preferred an application for.
Okay, please take down. Learned advocate appearing on behalf of the.
His name has been incorporated.
No. Whether you have filed the amended copy of writ petition?
But I need not
No,
file a
my
separate copy of this. I have to incorporate the name of the private applicant and I have to serve a copy the petition. And in course of today, I will incorporate his name.
No, the order is passed, the petitioner is directed to serve a copy of amended writ application.
The amended read copy has to be served upon me, my lord.
Only to him.
Yes.
I have to serve. But today, in course of today, I will amend the course.
We know it. You know.
কপি পাঠিয়েছিস তো তাহলে সাহেব আমি কি করে বলবো
তুমি এটা নিয়ে নাও
আমার দরকার আমি এতটা ক্যারি করতে পারবো না ভয়েস হচ্ছে আর এত সম্ভব
Petitioner submit.
Only one thing, before your lordship passes an order, the prejudice that the applicant is facing or the private respondent is facing due to pendency of this writ petition, my lord, despite being selected, my lord, the license has not been granted. Now, my lord, I know, my lord, there are matters, my lord, where, my lord, there is an order of stay. But, my lord, in certain similar cases, my lord, the authorities have proceeded, but to issue the license. Although the allotment has not been issued.
It was done illegally. That's why.
Madam, may I pray for...
Order is there, you know the fate of the order. Very well. Now. Petitioner submits that he could not serve the copy of the amended copy of writ application, writ petition to the added respondent number 6. Full stop. Let the matter appear after 6 weeks. In the meantime, the added respondent number 6 to file affidavit in opposition.
And when a reply by the petitioner, my lord.
Against the writ petition.
And may your lordship be pleased enough to grant me a leave to come up with a vacating application.
Vacating application? No, no leave can be granted.
Very well, my lord. I'm grateful.
Today in course of today, I will
No, it was incorporated. It was incorporated. I already mentioned in the order. Respondent number 6.
Lordship, I'm much grateful.
দিয়ে দেবো রে বাবা কেন দেবো আমাকে তুই ফার্স্ট বলি
I number 20, my lord, I am appealing for the respondent number
3 matters.
3 matters, my lord. May I indicate, my lord? I am appealing for the respondent number 6 in WPA 17585 of 2023.
17585
of 2023, my lord. Now, my lord, there are other 2 matters. That is 34179 and 3901. One was filed by my learned
petitioner.
My lord, one was filed by my learned friend, Mr. Das, my lord, and one was filed by my learned friend, who 3901 was the petitioner, my lord. My lord, they claim themselves to be, and they are the legal heirs and successors of one late Lokhinarayan Datta, who erstwhile had a MR dealer license, my lord. Now, my lord, in these 2 writ petitions, the 34179 and 3901, this court earlier in the year of 2015, my lord, granted an interim order of stay because they applied for compassionate appointments and before this court, and this court granted an order of status quo. Oh, that nobody will be no, because the legal heirs were on head-on collision on getting the license of their erstwhile father, late Lokhinarayan Datta. So there was an order of status quo over the license, my lord. Now, my lord, in the meantime, the state respondents declared a vacancy. Declared 3 vacancies rather. They say that these vacancies were declared out of their entitlements. However, I dispute that. Well, my lord, that is a pure question of affidavits, and that affidavits has already been exchanged, but I am not on that. Subsequently, the state respondents declared a vacancy. And my lord, in one of the vacancies, I was granted a license, my lord.
It was challenged by me.
Said vacancy was challenged by me, by him, WPA number 17585.
17585
of 2023.
85 of 2023.
23, my lord.
There is an order of stay also in that.
Now, my lord,
that's why both the 3 petitions.
All the 3 petitions, because this stay petition, this stay was granted
in consonance, because they say that it is in consonance of the stay orders of the earlier writ petition filed in 34179 and 3901, because they allege that the state respondent has violated the interim order passed in 34179 and 3901. They allege that. Now, my lord, subsequently, my lord, the state authorities has in the meantime, my lord, granted a license to me also, my lord. Now, my lord, they obtain an interim order in the 17585 writ petition, my lord. They obtain an interim order, and I file an application for addition of party, and I file an application for vacating Can 1 and Can 2 in 17585, my lord. Now, my lord, Can 1 has been allowed. I was added as a party. I am private respondent number 6 in the writ petition 17585. And with regard to the Can 2, my lord, the application, however, was said to be considered along with the writ petition. Now, my lord, I went on an appeal before the division bench, my lord. The honorable division bench, the order of appeal, my lord, will find in Can 4, because, my lord, the honorable division bench in that order directed the writ court to proceed expeditiously with the matter, since my rights has been violated. My right, I am continuously being hindered. In fact, after getting the license granted. Now, my lord, on the earlier occasion, a new fact unfolded in this writ petition, my lord. On a affidavit being filed by the petitioner in 3901, petitioner, my lord, in the meantime, may I indicate, my lord, the petitioner, because it's a long story, I just want to indicate the facts, my lord. The petitioner in 3901 also filed an application for addition of party in the writ petition 17585, who is another legal heir of, who claimed herself to the another legal heir of late Lakshminarayan Datta, my lord. Now, my lord, on his affidavit to the 17585 writ petition, my lord, on her affidavit, in the 17585 writ petition, it has been disclosed that the land on which the late Lakshminarayan Datta had go down doesn't exist at all. And on that score, my lord, kindly reads the order dated. Kindly peruses the order dated 28/3/2024, my lord, the last order, my lord. Now, this honorable court directed, because prima facie they have submitted a BLR report. The copy was served upon me also. They have submitted a BLR report on which the license of Lakshminarayan Datta is actually non-honest, because the lands on which the go down of Lakshminarayan Datta was alleged to be created doesn't exist in the records of at all. The BLR says so. Now, well, the state respondent had to file a report before your lordship, my lord. But, my lord, my point of continuity, why I am telling all this before your lordship, because the thing is that, my lord, I am being continuously suffering, and there is an express direction of the division bench that, and on that direction, I have also filed an application before your lordship in Can 4 of 2023, my lord.
For expeditious disposal.
For expeditious disposal of the writ petition, because the division bench is right, and in fact, my lord, I am suffering. I am suffering because of all this, and in fact, if tomorrow the state comes with an affidavit.
What is the status now? All the three petitioners.
No, the status now, affidavits has been extended. No, state has filed an affidavit, my lord. State has filed an affidavit. The state has filed an affidavit.
Took a proposal to, there's 3 vacancies. We took a proposal that all the, you kindly settle it in between the parties, we grant the license.
What will I settle, my lord?
We make a proposal. State also make a proposal.
No, the issue is not there. Issue that in terms of the order of this court, you have to file one report.
One supplementary report, my lord.
That is, what is the order? What is the order date?
28/3/2024, my lord, kindly see.
28/3/2024.
My lord, kindly see.
BLR, from the BLR.
State respondents are directed to file a supplementary report in form of evidence in respect of the aforesaid issue raised on behalf of the respondent number 6 within a period of 2 weeks.
Yes.
My lord, what issue you raise? That there is no go down.
No land in the name of Lakshminarayan Datta as per the Khotian number and as per
specific
the
mention
dag
number
and Khotian number that is appearing from their license itself.
Mention in the license.
License of late
What is where is your report?
Due to the elections, my lord.
Election has over.
Yes, my lord.
After that 2 weeks, no report.
Kindly answer.
Next week?
Yes.
Next week you file a
I'll give
report?
2 weeks time, my lord. 2 weeks time.
Requirement of 2 weeks.
BLR sent a report, my lord.
I am fixing a specific date.
So all.
Let the report be filed. Let them report be filed. First the report be filed.
Kindly 10 days time, my lord. Kindly give 10 days time.
Today is the 11th. You file on 20th.
1 week time is enough, my lord, because after 28/3/2024, my lord.
Okay, I understand. Next week, I am fixing on 20th.
My lord.
Okay. Please take down. An accommodation is sought for on behalf of the state to submit a report in pursuance to the order passed by this court on 28/3/2024. State submits that due to the election, the report is not prepared. The state is directed to submit the report in pursuance to the order of this court dated 28/3/2024 positively.
Lord, sir, instead of 20, only keep it at 24, my lord.
No,
Why 24?
No,
Sir, kindly-
Why
kindly
24?
that, my lord.
Lord, sir,
Because
kindly
from
is on
20
Kanzi, my lord.
2024, my lord,
Aray,
this
তুমি
is a-
challenge করো কেন?
my lord,
বলতে দাও আমাকে,
my
আমাকে
lord,
বলে
this is
দিতে
a this is a traversal of justice going on, my lord.
Let me hear the state. Yes.
Lord, sir, kindly keep it on 24, my lord.
Why?
Kindly. Because it is from Kandi, my lord. The official will come and affirm, my lord. Kindly keep it on 24, Lord, sir.
My lord, the officer should
Tell them come on next week, not this week. That is sufficient for them to come to the High Court. Where are they? Okay. Positively on 20th June 2024. Let the matter appear in the list on 20th.
Grateful.
On 2020, not 28. 0. Within 20th. Let the report be filed within 20th. Or no, within 20th June. March থেকে কিছু না। হ্যাঁ 6 হ্যাঁ ওটা ঠিক আছে 28/3/2024
Okay.
Give me the papers.
I beg to appear for respondent number 1 in this matter. My lord, I beg to appear on behalf of Union of India. Even a name.
Who is for the petitioner?
Perhaps they are not interested, I do not know. my lord.
My lord, I am appearing for the petitioner, my lord, virtually,
Sure.
with your lordship's leave, my lord.
Yes, you are
Sir,
not
I
audible,
apologize.
sir.
My lord, I am appearing
Yes,
on behalf
now
of
you
the
are
petitioner,
audible.
my lord. My lord.
Yes.
My lord, I was just praying for an adjournment, my lord, for a week, my lord. I'll come back with instructions, my lord.
What
Yes,
instruction? Affidavits
with-
have been exchanged, I think. No.
It passes an order for affidavit, that's better.
But there is already an order for filing of the affidavit in opposition. My lord, we had sought for leave to file a supplementary affidavit, my lord. But my lord, I have instructions not to file any further supplementary affidavit, my lord. If my learned friend wants to file his opposition, my lord, he can.
Grants us 3 weeks time, my lord, to use an opposition, my lord, so that we can.
Whether any report is required from the Union of India?
Lord, he is representing Union of India.
Yes.
Lord, the main answering respondent is Jute Commissioner. Answering respondent is Jute Commissioner, my lord.
Jute Commission.
Lord, but both stand is required to be brought on board. Same stand. That's why, my lord, an affidavit, my lord, not joint, separate affidavits may be directed, my lord. That will be better.
Let
my lord-
file the affidavit. Thereafter, if necessary, the Union of India may be directed to file.
Yes.
Okay. So,
My lord, kindly
within 2
also
weeks?
records on the last occasion, the petitioner said that they will be using a supplementary affidavit. Now it is coming from them that no supplementary affidavits will be filed. Kindly record that also.
Lordship, lordship.
order dated 1st August 2023, Union of India respondent number 3 also wants to file affidavit in opposition.
Affidavit in opposition has been filed by us.
File?
No, it
he-
has
he
not been
wanted to
filed.
file.
No, my lord, it has not been filed.
that.
My lord, it
Kindly
has not
extend-
been filed.
Order is there.
My lord.
Kindly extends that.
But no opposition has been served, my lord.
No, it has not been filed. I'm
Oh,
sorry.
I'm
It has
sorry.
not been filed.
Not been.
I'm sorry.
Kindly extend. Okay.
And also
please
kindly
take down.
record,
petitioner submits that he shall not file any supplementary affidavit in support of the writ application, writ petition, full stop. The liberty has already been granted to the respondent number 1 and 2, as well as the Union of India, to file affidavit in opposition. The time to file the affidavit in opposition be extended till 3 weeks from this date. 3 weeks from this date. Let the matter appear in the first week of July.
Lord, thereafter, affidavit
one humble
reply has
prayer,
been filed some
Okay,
time.
okay.
has to be granted.
The reply, if
just
any,
one
filed by the
clause.
reply, if any, filed by the petitioner
And
against
2
the
weeks,
affidavit in oppositions after 2 weeks thereafter. After
Great.
2 weeks.
Great.
Within 2 weeks thereafter. Within 2 weeks thereafter. Let the matter appear in the list on the second week of July.
Grateful.
Grateful.
Praying for the state respondents in this matter, my lord.
32, my lord, I'm for the petitioner, my lord, I'm praying for 1 week accommodation, my lord.
Now everything is ready, I think.
My lord. হ্যাঁ করতেই পারি করতেই পারি I am ready with the matter, my lord. Report in the form of an affidavit has been served. My lord, the exception has also been served, my lord. And it's a very short, my lord, issue to be decided.
Kindly allow me to make a call, my lord. Just
তুই কি এটা আছিস?
হ্যাঁ, স্যার, আমি on
তুই
duty
আছিস তো? ঠিক আছে, আমি এবারে আমি জাস্ট কটা পয়েন্ট আউট করিস করতে করতে আসুক। You know, may I point out the case, my lord, in short? May I place the case, my lord?
No, let the petitioner be first, please.
She is the advocate on record, my lord.
Yes, my lord.
You are for the state.
Your lordship kindly takes up my affidavit, the report in the form of the affidavit, my lord, which has been filed by the state on 28th August 2023. 28th August 2023.
Yes.
Your lordship has got it. The issue pertains to, my lord, whether a civic volunteer may be considered as a government employee. Very short issue. Your lordship kindly comes to page 25. The judgment. The earlier order, rather. Page 25. Paragraph 10.
Yes.
May I read out, my lord? The question as to whether a home guard holds a post in the establishment of a state government came up for consideration before a special bench of Allahabad High Court in the case of so and so, so and so. This special bench of the Allahabad High Court relied on the decision of the Supreme Court in the case of so and so, reported in AIR 1967 SC 834. In paragraph 9 of the Konok Chandra Supra, it was held by the Supreme Court that the question is whether a Mouzadar is a person holding a civil post under the state within Article 311 of the Constitution. There is no formal definition of post and civil posts. The sense in which they are used in the services chapter of Part XIV of the Constitution is indicated by their context and setting. A civil post is distinguished in Article 310 from a post connected with defense. It is a post on the civil as distinguished from the defense side of the administration and employment in a civil capacity under the Union of a state. In Article 311, a member of a civil service of the Union or an all India service of a civil service of a state is mentioned separately. And a civil post means a post not connected with defense outside the regular civil service. Here, my lord, your lordship kindly comes to paragraph 10. Next page. Paragraph 10. In this context of Article 309, 310 and 311, a post denotes an office. A person who holds a civil post under a state holds office during the pleasure of the governor of the state, except as expressly provided by the Constitution. A post under the state is an office or a position to which duties in connection with the affairs of the state are attached, an office or a position to which a person is appointed and which may exist apart from the independency of the holder of the post. Article 310(2) contemplates that a post may be abolished and a person holding a post may be required to vacate the post, and it emphasizes the idea of a post existing apart from the holder of the post. A post may be created before the appointment or simultaneously with. A post is an employment, but this is what is important because a post is an employment, but every employment is not a post. A casual laborer is not a holder of a post. A post under the state means a post under the administrative control of the state, means a post under the administrative control of the state. The state may create or abolish the post and may regulate the conditions of service of persons appointed to the post. Taking into account the aforesaid constitutional provisions and the scheme of the Home Guards Act, Allahabad High Court held that a Home Guard shall not be deemed to be a holder of a civil post. Next paragraph, Miller, which is relevant in our case. The position of a civic volunteer is more vulnerable than a Home Guard. There is no statutory recognition of a civic volunteer. They work on the basis of daily wage and under the scheme of no work and no pay. Next page, Miller. Therefore, they do not hold any civil post under the state government. In view of the above discussion, I have no other alternative but to hold that respondent number 6 does not hold any post, who was a civic volunteer in another case, does not hold any post under the state government. Therefore, he is entitled to the license of FPS shop, and the decision of the respondent number 4 does not suffer from any legal perversity. Now, my lord, your lordship, a employment notice was referred before the Honorable Court, which indicates that all the employment conditions of a civic volunteer was allegedly at par with any government employee. Your lordship kindly comes to page 28, the next page. The notice, followed by Miller, page 29, next page. Point 5, clause 5, page 29, clause 5. The selected volunteers will have no claim as to the employability in Kolkata Police or any other department of the government for such engagement. Specifically states, my lord, that the civic volunteer shall have no claim as to the employability in Kolkata Police or any other department of the government for such engagement. Clause 5 and clause 6, my lord, each such volunteer will be paid a honorarium at a rate prescribed by the government on furnishing of a working statement certified by the unit in charge. So, my lord, my most respectful submission is that, my lord, our point is very short. A civic volunteer, while being considered to be allotted as for the shop, my lord, should not be considered as a government employee. In terms of the notification which has been indicated by the petitioners issued by the government, and in terms of the judgment, my lord, that I have referred earlier. This is my submission, my lord. The precondition of the employment, the engagement, specifically states that he will have no claim in any other department of the government for such engagement or as a government employee. Clause 5 and 6. This is to be read, my lord, in along with the part of the judgment that I have placed, my lord.
My lord, I appear for the petitioner, my lord.
They have got some personal issues, my lord, due to which the matter has been tracked before the honorable court.
নো পার্সোনাল
তাহলে এটা হয় না
কোনটা কি পার্সোনাল
যে ও কেন যাবে আমি কেন এখানে
what no nothing lordship may kindly allow me to submit my lord.
Yes.
Lordship may kindly consider the judgment which my learned friend has referred to, my lord. Learned of judgment of Honorable Justice Vivek Chaudhary. My lord, I am relying upon this judgment and I have cited this judgment before Justice Vivek Chaudhary and I obtained an interim order. Relying upon this judgment, Lordship may kindly consider page 8, paragraph 10.
Yes.
My lord, it's paragraph 10. The question as to whether a home guard holds a post in the establishment of any state government came up for consideration before a special bench of Allahabad High Court in the case of Rajiv Singh versus State of UP and others, decided on 1st October 2018. The special bench of the Allahabad High Court relied upon a decision of the Honorable Supreme Court in the case of State of Assam versus K. Chandra Datta, reported in AIR 1967 SC 834. Subject to correction, it should be 884. The paragraph 9 of Kanak Chandra Das Supra, it was held by the Honorable Supreme Court. Paragraph 9 of Kanak Chandra Gupta is quoted. The question is whether a Mazdur is a person holding the civil post under the state within Article 311 of the Constitution. There is no formal definition of post and civil post. The sense in which they are used in the service chapter of Part 14 of the Constitution is indicated by their context and setting. A civil post is distinguished in Article 310 from a post connected with defense. It is a post on the civil as distinguished from the defense side of the administration. An employment in a civil capacity under state or a state, under the union or a state. In Article 311, a member of a civil servant of the union or all India service or a civil service of a state is mentioned separately, and a civil post means a post not connected with defense outside the regular civil service. A post is a service or employment. A person holding a post under the state is a person serving or employed under state. The heading and the subheading of Part 16, Part 14 and Chapter 1 emphasizes the element of service. There is a relationship of master and servant between the state and the person holding a post under it. The existence of this relationship indicates by the state's right to select and appoint the holder of the post, its right to suspend and dismiss him, its right to control the manner and the method of his doing the work, and the payment by it of his wages or remuneration. A relationship of master and servant. My lord, this is very important. A relationship of a master and servant may be established by the presence of all or some of these indica, the conjunction and the other circumstances, and it is a question of fact in each case whether there is such a relationship between the state and the alleged holder of the post. In the context of Article 309, 310 and 311, a post denotes an office. A person who holds a civil post under state holds office during the pleasure of the governor of the state, specially and expressly provided by the Constitution. A post under the state is an office or a position to which duties is connected with the affair of the state are attached. An officer or a position to which a person is appointed and which may exist apart from the independently to the holder of the post. Article 310 Article 310 contemplates that a post may be abolished and a person holding a post may be required to be vacate the post, and it emphasizes the idea of a post existing apart from the holder of the post. A post may be created before the appointment or simultaneously with it. A post is an employment, but every employment is not a post. A casual labor is not a holder of a post. A post under the state means a post under the administrative control of the state. The state may create or abolish the post and may regulate the conditions of service of a person appointed to it. Now, my lord, my submission is Article 311 says you should have a disciplinary control over the employee. I am the employer, and anyone if is my employee, then I can punish him. If it comes, then it comes under the definition of a post. My lord, if lordship may kindly comes to page 30 of their reply filed by the state. It starts from page 28, the notification issued by the government of West Bengal with regard to employment and recruitment of civic volunteers. It starts from page 28. And lordship may kindly comes to page 30.
Yes.
Page 30, my lord, disciplinary matters, first heading. All civic volunteers will exhibit highest degree of discipline and devotion to the government duty. These civic volunteers will be liable to be demobilized temporarily or permanently by Deputy Commissioner of Police, Home Guard, Organization, Kolkata for noted reasons: dereliction from duty, indisciplined conduct, involvement in criminal case other than petty cases, long unauthorized absence from a duty, indulgence in corruption, extortion, exhibiting conduct which is found to be unbecoming of a volunteer deployed in the assistance of the police, incapacitated or medically unfit, any other reasons caused to be determined by head of the unit. My lord, if my employer can take disciplinary action against me on these grounds, then I come under the definition of an employee. If I am an employee, then I can't participate in this fair price shop.
No, what is the
my lord, this is the
Clause 5 and 6.
my lord, this is the law.
23A.
Clause 20
3A
of
WBDS. That is, okay, you can read it at page 24
page 24 of the
of their reply.
1 minute.
Where the persons are not eligible to be a fair price shopper.
The persons
This is the statute. This is the statute. We have to go to it.
Yes, it is the statute, my lord. Clause 5.
No, you read it at page 24. Page 24, para 8. At their reply. This is the.
He is relying on clause E, which is absolutely unsustainable.
Lordship, page
24 of their reply.
Page 24 of their reply.
Paragraph 8.
Paragraph 8.
E.
That is the clause.
A person holding a post in establishment or
Following person shall not be eligible to apply for a license of a dealer.
Following person shall not be eligible.
Statute.
This is the advertisement. This is the
statute.
This is the statute. This is the advertisement which runs clause 2 of the Maintenance and Control Order 2013.
Yes.
The provisions runs thus.
Yes.
The following person shall not be eligible to apply for license of a dealer, namely.
Yes. E.
E. A
Yes.
person holding a civil post.
Holding a post
A
in the
post in
establishment.
establishment of any state government or central government. Well, it goes in my favor. Or any, don't interrupt, or any other authority or bodies or institution or local self-government established or constituted or under the constitution or by any other law made by the parliament or state legislature or by
That means
notification.
statutory recognition is required
Statute
for a post.
for a post.
Yes.
And if
For a post of state or central,
for a post of
statutory
center
recognition is required.
and my submission and relying upon the judgment,
Statutory recognition of civic volunteers.
yes, if I go by the judgment, it says I can take punishment. If I can punish him, then he's my servant. He's holding a post. That is what the Supreme Court has said, and that has been reflected in the order.
No, that is not the statutory.
Well, no, that is not the statute.
No, let me explain.
My lord, please.
Statutory recognition not only give the power to the boss to punish the servant. That statutory recognition means in the state, in the Union of India, all statutory recognition is upon the also servant that you may have some authority.
Lordship,
Your post.
yes.
That requires the statutory recognition.
My lord,
of
may I
any post.
interrupt for a
Lordship may kindly have a look
even
to
the
section.
security guards appointed by different security agents have the same disciplinary condition.
That is a private
That is-
arrangement.
Those
are private
they are
arrangements. Those
basically
Submission-
tertiary
I
issues.
understand.
Your
Yes.
lordship kindly comes to
civic
page
volunteers
26
and
for
security persons
Your
are
lordship
private
kindly
citizen persons are different.
Your lordship kindly comes to page 26 for once minute at the cost of repetition. Page 26. Paragraph 11.
11 and 12.
Taking into account the aforesaid constitutional provisions as referred by my learned friend and the scheme of the Home Guards Act, Allahabad High Court held that up. Home Guards shall not be deemed to be a holder of a civil post. Paragraph 12. The position of a civic volunteer is more vulnerable than a home guard. There is no statutory recognition of the civic volunteers. They work on basis of the daily wage and under the scheme of no work, no pay. Therefore, they do not hold any civil post under the government. It has been clearly stated, and this order has never faced any appeal till date.
Well, this order.
In view of the above discussion, I have no other alternative but to hold that respondent number 6 does not hold any post under the state government. Miller, this is to be read with page 29, clause 5 and 6, where it has been categorically mentioned that the selected volunteers will have no claim as to the employability in Kolkata Police or any other department of the government for such engagement. Each such volunteer will be paid an honorarium only at a rate prescribed by the government on furnishing of working statements by the unit in charge. By no way, stretch of imagination, my lord, the civic volunteers or the home guards can be considered as civil posts. This is my more respectful submission.
Is there any authority on your behalf?
Lordship, I have one authority, Lordship. Kindly take it up next day, any day. I will show up the authority. And apart from that,
Only the question.
only the question. My
Fine.
Lordship.
The question, just explain me, both of you. Please read out the notification. Employment notification. First line.
Right.
First paragraph. Applications are invited in the prescribed format for women candidates only for engagement of civic volunteer and such and such. Thereafter, for engagement as civil volunteers under the unit mentioned in serial number 10 of the table below, against the post
Sanction.
Sanction in terms of government of West Bengal and Home Hill Affairs. This in terms, my lord, includes the clause 5 and 6, which specifically
whether by this notification government declared any post?
Yes.
No.
Yes. I'm coming.
Milord,
Let him submit.
That's why I am asking.
Milord, it is categorically
I'm
grateful,
Milord, in clause 5 and 6, they speak categorically that they are not going to have any government post whatsoever.
No, you have the paragraph 12 of the judgment also.
My lord.
The civic volunteer.
Paragraph 12
no
is to
statutory
be read with is to be read with clause 5 and 6 of the notification, my lord.
Okay, you come with any authority like that?
Lordship, I'll be coming with an authority. And now, yes, Lordship, kindly fix a date. I will come with an authority. Apart from that, there are something on the facts which I can show you on the next day, my lord. It says, the advertisement says, if you are appointed.
I'm making it parted.
Certainly, my lord.
I'm making it parted.
Certainly.
Next week, when?
Subject to my lord's kind sanction.
My lord's convenience.
8 तारीख से देखो ना कल.
Parted matter will take up fast. Okay.
My lord, any date except 18th. 18th तो
Except
असुविधा
18th.
After 18th, any date, my lord.
18th and 20. And 20.
Except 18th and 20th.
That is now come on 21st.
21st.
Friday.
Friday.
Malik, then can it make it on Monday, Malik, 24th? It will be better.
As you wish.
24th. ঠিক আছে?
Check down. The
My
matter.
lord, calendar 25th, 24th আমার fixed আছে.
No, বলো,
Very fixed আছে.
বলো না, বলো না.
25th, Tuesday.
25th is the Tuesday at 2 p.m.
At 2 p.m.
Matter made parted. That the matter fixed on 25th at 2 p.m. as a parted special fixed matter.
Grateful, my lord.
Well, before your lordship rising, item number 3 of the today's list is fixed at 2 p.m. There is a resolution not to participate in the proceedings due to death of senior advocate Arendas.
Today.
So, my lord, your lordship, kindly erase the 2 p.m. Tomorrow at 10:30, we don't have both sides present. We have no difficulties because matter fixed at 2 p.m. If it is appeared tomorrow,
First matter.
First matter.
Parted matter is first.
Not 2 p.m. in the morning.
In the morning, first matter.
I'm good.
Okay.
Item 3.
Just call the list.
33, my lord. We allowed to virtually. Yes, there is a resolution I came to know, my lord. I appear for the private respondent, my lord. My junior is there. No petitioner.
Okay, not to pass any adverse order. This
Yes,
is the
yes, yes.
resolution. Today, this is all the
That
matter
is-
will come up on tomorrow. Okay, in the list. No issue. Just call the item like that. 33 to 40, 40 to 50, like that. Call the items. 34,
37, my lord, I beg to appear on behalf of the petitioner. 37, my lord. Oh, sorry, my lord. Excuse me, sir. 38, my lord. 38, my lord. I am appearing on behalf of the petitioner. Yes, my lord. My lord, there was a direction to file supplementary affidavit, my lord. We have already served it upon the respondents, my lord. In compliance of my lord's last order, my lord, there was a direction of.
Have you served them?
Yes, yes, my lord. My affidavit of service is also there, my lord. I am filing the supplementary affidavit along with my.
Item number 38.
38, my lord. Swaroj Rai versus State of West Bengal. Last order था तो last order. My lord, kindly takes the order dated 1st of December 23, my lord. My lord, internal page 2 of the order, first paragraph, my lord. That was the direction, my lord. Affidavit copy touch, supplementary data dilam, copy touch.
Yes, supplementary affidavit.
Yes, my lord. I have already served upon the state, my lord, along with affidavit of service, my lord.
Yes.
Along with affidavit of service, my lord.
Ah.
Affidavit of service, my lord, long back, my lord. In compliance of the order within time, we have served it upon, my lord. कत तारीख में दिए
21/12/2023
My lord, on 21st of December 23 we have served. My lord, this is distribution of fair price shop, my lord. We were having 7,080 card holders, my lord. Now, lord, in the same vicinity, my lord, state has again appointed another distributor, my lord.
Is there two supplementary affidavits?
Yes, my lord. One supplementary affidavit filed, my lord, inadvertently, my lord, only net disclosure of income we have filed, my lord. There was another aspect, my lord, if my now, my lord, the direction was upon us to, my lord, to substantiate that how much we are getting out of per card, per ration card. What is our income out of per ration card, my lord? Now, that was not made clear in the first affidavit, my lord. So, this second supplementary affidavit, my lord, we have given the details, my lord. That how. My lord, it
First
compared.
affidavit shown on 8th of September 2023.
Yes, my lord. If my lord may kindly take the second affidavit which you have filed today, my lord. This is the comparison that what we are receiving when we are serving 7,080 card holders.
Very
And and at present, my lord, when we are serving 60, my lord, income is 0.28 paise per card. Now, my lord, only net income which we are deriving, my lord, as of now is 1,300 rupees per month. Because for 16 days we have to serve for Duare Sarkar, there is a scheme. For 16 days we have to accommodate for transportation, my lord. Now, this income also consists of 5,000 rupees, my lord, which the state government pays off for keeping a staff, my lord. So an employee also, incentive for an employee is also covered with this amount, my lord. We have given how much amount we have received, my lord. We have annexed with that, my lord.
Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Supplementary affidavit filed by the supplementary affidavit filed by the petitioner is also taken on record. Supplementary affidavit in pursuance to the order dated 1/12/2023 filed by the petitioner is taken on record. Respondents are at liberty to file affidavit in opposition.
My lord, may just madam, my lord, the state was supposed to file a report, my lord. But as of now, my lord, kindly takes order dated 12th of September 23, my lord, the earlier order.
Yes.
The state was supposed to file a report, my lord. There was a direction upon the state to file a report. No report has been filed, my lord. What? No adverse order. Both side not থাকলে adverse order কি বললাম বলো নিউ রেজোলিউশন হিয়ারিং বুক আমাদের বলা হয়েছিল
Against the supplementary affidavit.
এখানে আসছে দেখছি
State was directed in pursuance to the order of this court dated
not to pass it
12/9/2023 to file an affidavit, file a report in the form of affidavit, but it was not filed. Today,
may I make one submission, Your Lordship? I am the executive committee member of the Bar Association, Your Lordship. There was a resolution adopted by the Bar Association on the start demise of.
yes, I understand, but I am not passing any adverse order. I am just taking the supplementary affidavit which was served, which was already served. Okay.
কি কাকে সাপ্লিমেন্টারি দিয়েছে সাপ্লিমেন্টারিটা ফাইল করে দিন হ্যাঁ আর্টিকেলটা কোন আছে
তিন মিজানুর
না না এটা হচ্ছে তো না না কিছু না অমৃত আছে
হ্যাঁ কি বল লাস্ট দিনের অর্ডারটা আছে দেখাও না আগের দিনের অর্ডারটা
লাস্ট অর্ডারটা
In terms of resolution adopted by the bar, no adverse report can be, no adverse order can be passed. According, the matter is urgent today. List the matter tomorrow.
Tomorrow, my lord. Great, my lord. Let it.
All the matter will appear on tomorrow.
Yes, my lord. Since there is a resolution, let the matter be appear.
Yes, my lord, it is my duty to inform your lordship that there is a resolution of the Bar Association.
I understand.
Great, my lord.
Great.